Hello and a hearty welcome to this Christmas Eve edition of A Quarter Hour with the Human Rights Wizard on your favorite channel, Human Rights Heralds. I am still your usual host, Ogochukwu Onoha, the Human Rights Herald, Human Rights Wizard. Remember that evil persists because good people refuse to say or do something. Therefore, if you see something or hear something, then say something. If you see some unusual conduct around your environment or surroundings, say something. If you are involved in a situation of human rights, a situation involving some rights violations, and you do not understand clearly what has happened, ask questions. By the time you ask 2 or 3 persons, you will get the answer that you need. And remember that here on Human Rights Heralds, we are always at your service. Make a call. Do not sleep over your rights. Make a call or send me a WhatsApp post on 091 333 1790. That is 091 333 1790. Or call the hotline 0806 5422 624. If you do this, I can assure you that you will get the help that you need. Today, we are on to episode 11 of Human Rights Heralds, A Quarter Hour with the Human Rights Wizard. And our focus today is on eviction and the rights of a tenant. I am sure that if you are one who lives in a property or who is resident in a property which is not yours, in other words, you are a tenant, or someone who was once a tenant or who intends to be a tenant in someone else's property anytime in the future, you will be interested on our video today. Now remember that you can help us to reach a greater number of persons if you like, share this video and subscribe to this channel. This way you will be helping us to reach a greater number of persons who need the information that we provide here. Remember that it is all about human rights education and the effort to simplify the technicalities in the laws affecting your rights so that you get to understand these rights better and be more equipped to observe them and help others around you to do so. So today, eviction and the rights of a tenant. Remember to watch our previous video, that is the video on episode 10, where we discuss tenancy and the law of contract. We know what eviction is, don't you? It means to send a tenant packing from the property where he had resided or she had resided as a tenant. In this video, we shall be exploring the conditions that can lead to the eviction of a tenant and the rights which tenants have in such a situation. In our last video, we talked about the duties of a tenant. Remember that the duties of a tenant are the rights of a landlord. Today we are talking about the rights of a tenant, which of course constitute the duties of a landlord. Let us begin with the contractual documents that spells out the responsibilities and the duties that exist between the landlord and a tenant in a tenancy agreement. There is a technical word often used here. It says that the landlord hereby pledges to let the property, that is, give the property to the tenant with all the appurtenances attached. Appurtenances means facilities like kitchen, a suite of bedroom and toilets, and a courtyard, maybe a parking lot for parking, and other such facilities like kitchen, a parking store, and so on and so forth, that are a part of the property rented by a tenant. Now that is the first right of a tenant. Having made the requisite payment, that is the rent which the tenancy agreement imposes on you, as a tenant, you have the full right to enjoy all the facilities attached to your apartment, including the right to private and family life. The Constitution of the Federation of Nigeria, 1999, as amended in Section 35, also guarantees this right to private and family life. What this implies is that the landlord may not simply walk into your apartment. No, he has to announce his arrival by possibly knocking on the door or pressing the doorbell and wait to be admitted before he can walk into the apartment. That is the right of the tenant. Now let us take a look at other rights. Does the tenant have the right to attach something to the building? Yes, to a certain extent. I'll give you an example. You move into a property and the doors do not have burglary proofs and the windows do not have any, and you think it is unsafe to live in the apartment without this burglary proof, and you decided to install one yourself. Now this is the law. Anything attached to a building permanently becomes a part of the building. So, if you install a burglary proof to the door of your apartment and some burglary proofs to the windows, assume they didn't have one already, they become a part of the building. You can't remove them while living the property. They become the landlord's property. So how can this be done? First, you need to approach the landlord and tell him to install those protective measures, burglary proof. He will install them at his own expense. But very often, landlords are reluctant towards doing this. And then if the tenant decides to do it on his own, at his own expense, then the tenant will want to take them away while living the apartment. And this is where the quarrel, the loggerhead sometimes arises. Many landlords frown at tenants defacing their buildings defacing the walls of the house by trying to remove burglary proofs. So how do we go around this? The law does not allow the tenant to do that. So what you should do is get the landlord to enter into an agreement with you. You install the burglary proofs, then he deducts the amount you installed from the rent you pay, and then the burglary proof now becomes the landlord's property, becomes a part of the building. Or you make an arrangement to install them and the landlord pays for them. The landlord pays the expenses. In which case, the property, the burglary proof becomes a part of the building and the landlord's property. But what if you simply want to take your burglary proof with you while living in the apartment? Then you must enter into a written agreement with the landlord stating that whenever you decide to evacuate from that property, that you will take your burglary proof away with you. Once the landlord signs or endorses the agreement, he cannot deny it when it is time for you to take that property away from the building. Now remember, every item attached to a building becomes permanently a part of that building and cannot be removed except there is an agreement to that effect. Good. Secondly, there are items that can be attached to a building but not permanently, and so those ones can easily be taken away. For instance, your ceiling fan is hung below the roof of the building and can be taken away whenever you want to do so. So such items that are not permanently attached can be taken away, but the ones that are permanently attached to a building become a part of it. Now let's talk about what is often called illegal structure. Illegal structure. Can a tenant erect a structure in the property he or she has rented? No. This is unacceptable. It's against the law. It is not the right of a tenant. But the tenant has the right to approach the landlord and say, I want to do this, and I will remove it later. If the landlord accepts, then there is an agreement that you can erect a structure. Sometimes it is a makeshift structure. I'll give you an example. You live in a property, as frequently happens, you have a farm close to the property, and you want to harvest your cassava, you want to process it to become gari. So you need a makeshift shelter where the processing, the frying of the gari will be done. If you fail to tell the landlord and you do that, it could become enough ground for the landlord to try to recover his property from you. But if you tell him beforehand and he accepts, then it becomes an agreement. So after erecting the structure, then you demolish it after making use of it. But there are some structures that are not permanent. Assume, for instance, an event is to hold in the property. Then you can bring canopies and erect them. These are impermanent structures. You do not need the landlord's permission to do that. The landlord himself has no right of entry into the property because this might be seen as a nuisance by the tenants. But because of this, there is usually a clause in the tenancy agreement permitting the landlord entry into the property for the purpose of inspection. If the landlord does not, if there is no such clause in the tenancy agreement, then the tenants have the right to stop the landlord from entering the property. The landlord cannot host an event in his own property without the tenant's approval, except it was written in the agreement that the landlord has the right to hold such event whenever the need arises and the tenant signs, then it becomes a part of the agreement. I am sure you have questions or you have observations. Please, if you do, drop your questions, observations on the comment section, and I will respond to them in due course. Now let's talk about maintenance. Whose duty is it? Now, maintenance of the property is partly that of the landlord and partly that of the tenant. If a facility in the building gets spoiled, of course, as you enjoy the facilities, they wear down and need to be fixed. I'll give you an example. The wash basin, the pipe attached to the wash basin in your kitchen gets broken, or the valve that enables water to be channeled through it down to the soakaway gets loose, and the water begins to leak and soak your kitchen, you need the service of a plumber. At whose expense? At the expense of the tenant, not that of the landlord. A tenant must be so responsible that he takes care of the properties or takes care of the facilities that he uses in the compound. So it is the duty of the tenant to fix any problem that occurs, any problem that happens, any fault that is detected on the facilities in his or her apartment. So, if there is a faulty device or a faulty fixture inside the building, it is the right or the duty of the tenant to fix it. What about outside the building? Then it becomes the landlord's duty. I'll give you an example. The gates leading into the property gets damaged or is too weak, and the tenants want it replaced with a strong one. The duty of the landlord. It is the right of the tenant to get the landlord to fix it at his own expense. The sock away pit fills up. Who drains it? The landlord, because it is outside the building. The landlord drains it at his expense. I'll repeat that. If the wear and tear happens, so facilities within or inside the building, it is the duty of the tenant to get it fixed. But if it is outside the building, it is the duty of the landlord. So if the roof gets leaking, the landlord has to fix it, not the tenant. The landlord has to fix it at his expense. The gate is sock away. The wall gets broken, the landlord has to fix it and not the tenant. These are the reciprocal rights and duties which tenants and the landlords perform to the advantage of each other. So now we talk about eviction proper. What are the rights of a tenant, and what does the law say about the eviction of a tenant? Now let's talk about the categories of tenants, as this will help us understand this issue better. Weekly tenants pay every week. Fortnightly or 2 weekly tenants pay every 2 weeks. Monthly tenants pay their rent every month. 6 monthly tenants pay their rent every 6 months. And the yearly tenants pay every year. If, for a reason, the landlord decides to recover his property from a tenant, he has to get a lawyer, and the lawyer will serve the tenant a notice to quit. Usually the notice to quit will have a duration commensurate with the length of time during which the tenant pays his or her rent. So a weekly tenant is given a week's notice to evacuate from the property. A 2 weekly tenant is given a 2-week notice to evacuate from the property. A monthly tenant receives a month's notice to quit, to evacuate from the property. A 6 monthly tenant and a yearly tenant both receive a 6-month notice to quit. Now, what does the notice to quit imply? Let us use the yearly tenants, because most people are yearly tenants, most tenants are yearly tenants. Let's use that as our case study. You pay your rent every year. Now, the landlord decides to serve you a notice to quit, that is, to leave the property. There might be a number of reasons for this. You are the tenant, you might have violated some of the duties that the tenant is expected to perform, some of those duties that we enumerated in our video on episode 10. If the tenant has violated one of those duties, does not perform one of those duties, it is enough ground for the landlord to seek to recover his property. Another is that the landlord wants to make use of the property, that is, wants to make use of the apartment himself, or he wants one of his relations to make use of the apartment, to live in the apartment. The law permits the owner of the house to do this. Then he serves the tenant a notice to quit. It is also possible that the building is in a bad state, in a bad condition, and the landlord wants the tenants, all the tenants, to quit so that the building can be renovated. It is enough ground for the landlord to serve the tenants a notice to quit. It is also possible that the government no longer wants that area to be a housing estate or to be a residential area. The government wants to build a public facility there, and everybody is served a notice to quit. There's also enough ground for the landlord to serve the tenants a notice to quit. Now, in all of these cases, the landlord will serve the notice according to the length of time the rent is paid. So in the case of a yearly tenant, he is served a notice allowing him to evacuate from the property within the next 6 months from the dates on which the agreement, on which the notice was served him. That is, from one period in a month to another. This is the way it is signed. The notice to quit begins from the beginning of 1 month. It doesn't bear a date in the middle or towards the end. It has a date starting from the beginning of the month and end at the beginning of another month, or at the end of another month that completes it 6 months. That makes it 6 months. That's the way it should be. And then while the tenant lives for those 6 months, the tenant will continue to pay his or her rent while trying to raise money to rent an alternative accommodation elsewhere. That's the way it should be done. What if the period expires and the tenant has not evacuated? Then usually a 7-day grace is given. The landlord, through his lawyer, will serve the tenant another notice, giving him an additional 7 days to evacuate from the property. And if the 7 days expires and there is no evacuation, then what will happen? Many corrupt landlords will employ or hire the police secretively, because it's a violation of the law. The landlord will collude with some corrupt police officers and throw the tenant's property, the tenant's personal belongings, outside the apartment. Park the property somewhere outside the building where the tenant can pick them when he or she lies. This is what is called in law self-help. Self-help is upheld by the law. It is an infringement. It is an infringement on the right to personal dignity. The right to human dignity of the tenant is infringed whenever a landlord does this. Unfortunately, this is sometimes rampant for reasons I will explain in a couple of minutes' time. But let's talk about what the landlord should do if after the 7 days of grace, the tenant does not quit the property. Now what will happen is that the landlord, through his lawyer, will approach a magistrate court and obtain a writ of summons. That is a document informing the tenant that the case has appeared in a law court. Now, why is this important? If the case appears in the law court, the tenant is protected. You appear in the law court. The magistrate will usually want to find out why you've not been able to evacuate from the property. And then you will give reasons. Sometimes it is financial, or frequently rather, not sometimes. It is financial. Then the court will ask you how long you think you can still stay there before you raise money to evacuate. If you say 2 more years, if you say 3 more years, it is final. The landlord has no say anymore, because nobody can be forced out of a building when he has no alternative place to go. So the court will allow you that time, while warning you to make sure you do not stay beyond the 3 years you have pledged. If at the end of the 3 years you are still unable to leave, then the court itself will authorize police officers to go to move into the property and take you and your belongings away. Now, very often, the non-payment of rents is a reason why many landlords want to recover their properties from the tenants. What does the law say about this? The law says that if a tenant's rent is in arrears for 3 months, that it is enough ground for the landlord to recover his property from the tenant. Remember, I said it's enough ground. The law does not say once a tenant's rent is in arrears for 3 months, the landlord should immediately recover his property. No. The law says it's enough ground. What this implies is that after 3 months and you have not paid your rent, if the landlord can no longer have patience, if he can no longer bear with you, then he should initiate the process of recovering his property. And the process was what I just enumerated. Now, there is so much to be said, but we have to end it here because this is what space and time permits us. Remember, like I said earlier, that evil persists because good people refuse to do or say something. So if you see or hear something, please talk. If you see suspicious conduct in your environment, talk. Do not be quiet. And do not slip over your rights. Most often, landlords, unscrupulous landlords, eject tenants forcefully out of the property using the help of the police. This happens because they realize that this is often a most vulnerable period for the tenant. Most tenants are vulnerable when issues of rent are involved. The tenant has no money even to feed the family or take care of the medical bills or pay the school fees and so on and so forth. And the rent is accumulating. And the landlord understands that the tenant is vulnerable. He is helpless. I will not be able to challenge him if he decides to force him out of the property. What do tenants do in such a situation? They lament and cry silently in their houses, asking God to intervene. No, you don't need to do that. Like I said, you need to talk. What should you do? Report to the closest human rights organization. Seek the service of ADR. ADR is Alternative Dispute Resolution. If you contact this channel, if you have such a problem, I will refer you to a human rights organization around the country where your landlord can be invited along with you and the matter will be resolved without going to court. It's called ADR, or Alternative Dispute Resolution. And if it becomes necessary that the matter has to appear in court, for instance, if the landlord has taken the matter to the court already, and you are vulnerable, you have no money to hire a legal representation, then call on this channel. Reach out to me on WhatsApp using the number 091-333-01790 or call the hotline 0806-5422-624. If you do so, I will link you to a human rights organization that will give you assistance. The National Human Rights Commission is located in all state capitals in Nigeria, and then the Legal Aid Council of Nigeria provides free legal service for tenants who have such a problem and other Nigerians who face litigation or lawsuit without having money to hire a legal representation. And there are privately owned human rights organizations which do it even better. All you need is reach out to me, reach out to this channel, and I will link you up to one of them. You do not need to sleep over your right, because in the words of the late Steve Biko, the greatest weapon in the hands of the oppressor is the mind of the oppressed. Because the oppressor understands that this is the mindset of the oppressed. I know he will not challenge me. If I do this, he will do nothing. So they go on to do it. So you need to talk when you're facing any of such problems. My treasured viewers and listeners, I want to thank you all for being a part of history today. And remember, like this video, share this video, so that it can have a greater reach than would otherwise be the case. We rely on you very much to help us propagate this video, and subscribe to this channel so that you can help us to do more. I want to say a happy Xmas to you and your family as we welcome the birth of our Lord Jesus Christ. Remain blessed, celebrate moderately, do not overdrink, do not overdrive, do not overeat. It is a moment of joy, not one of sorrow. I want to say a good bye to you as I wish you a happy and eventful new year ahead, a year that you realize all those good wishes have been smoldering in your heart. I am still your humble host, Ogochukwu Onoha, the Human Rights Wizard.